皆様こんにちは。米国のマッケンジー法律事務所の弁護士の増本です。本日は US Litigation Now 3の第3回目といたしまして、米国訴訟における文書やデータの保存の必要性についてお話をさせていただきたいと思います。本日のスピーカーは、これまでのシリーズですでにご紹介させていただいております。弊社サンフランシスコオフィスパートナーのマーク・グッドマン弁護士と、ワシントン DC オフィスパートナーのジェニファー・セムコ弁護士です。Mark and Jennifer, thank you for joining. Today's topic is document preservation under the U.S. litigation. We often hear that when it comes to U.S. litigation, companies have a duty to preserve documents and data that might be used in the case. Is that correct? And why is that the case?
Sure, Mika. Thanks. And it's good to be here today. Yeah, so this issue that you just raised, document preservation, is one that we discuss with our Japanese clients quite a bit because it is one that is quite unusual anywhere outside of the United States. As our friends who have followed our webinars and video chats would know, in the United States, there is a very broad right to discovery. And so as part of that right to discovery, meaning that the parties to a litigation have the right to obtain and have the obligation to produce their documents that are in their possession, custody, or control. Courts want to ensure that parties get all of that information. They do not want parties destroying information that would otherwise be allowed to be obtained in discovery. So there are rules in the United States, and of course, as we have said in all of our cases, the United States has different jurisdictions, so the rules are a little bit different depending on where you are. But as a general rule, U.S. courts will require parties to maintain their documents, preserve their documents so they can be provided in litigation. So what we really have to watch out for is clients or potential clients that have practices where documents are destroyed on a regular basis, because if there's litigation, that can't happen, or there are sometimes adverse consequences to the parties for destroying such documents.
So when does a Japanese company have to preserve documents? What is the trigger of the obligation of document preservation?
Well, I'll take that one, and this is a really important question because some Japanese companies are under a misperception that even though they recognize they may have a duty to preserve documents for U.S. litigation, they mistakenly believe that that duty does not come into play until the lawsuit is actually filed. But that is typically not the case. Most U.S. courts have held that this duty to preserve is triggered even earlier, as soon as litigation is reasonably foreseeable. So certainly a duty to preserve documents is triggered once the suit is filed, but there are many situations where the duty comes into play much earlier than that. For example, a company might have a duty to preserve documents when they receive a demand letter or a threat from another party, or when the company itself determines that there's a dispute that is likely to go to court. Both of those situations can trigger the duty. Many times, when exactly the duty to preserve is triggered is not completely clear, and this is often a hotly disputed issue in litigation, and courts often are asked to determine whether a party to a lawsuit acted quickly enough to preserve its documents. And so there can be a lot of tricky situations. For example, if parties are negotiating a dispute in a friendly way with a goal of preserving their commercial relationship, you could argue that even though there's a disagreement, the duty to preserve is not yet triggered. But if those negotiations start to become adversarial or start to break down, and certainly if either side threatens litigation, then the duty would be triggered. Some courts have found that when a company hires counsel to give them advice on possible litigation, that this triggers the duty. But suffice it to say, there can be some gray areas there in terms of when the duty is triggered. And certainly there are lots of disputes about the scope of the preservation. Did the litigant not only start to preserve documents early enough, but did they preserve enough documents? And for all of these reasons, it's very important that not only a company's legal department, but also its employees understand this U.S. obligation so that they can be aware of the circumstances and be prepared to alert company leadership if situations arise that might trigger this duty to preserve documents.
What could happen if a Japanese company doesn't comply with the U.S. court's expectations?
So there could be really significant consequences if a company fails to preserve documents early enough and broadly enough. In the U.S., we call a failure to preserve documents that are then lost or deleted, we call that spoliation in the United States. And the penalties for spoliation can vary. It will depend on the type of documents that were lost and how significant they were. It can depend on how much harm the loss of the documents causes to the other side. And it can even depend on how culpable, how guilty the party is that deleted the documents. So the most severe punishment would be a complete dismissal of a party's claim if the party that didn't preserve the documents is the plaintiff. If the party that failed to preserve the documents is a defendant, the judge might rule that that defendant can't raise certain defenses, which would be very damaging to the defense of the case. A company that engages in spoliation might be required to pay the attorney's fees of the other side, for example, the fees that the other side might spend to address the issue and raise it with the court. Another common penalty is something called an adverse inference. This is where the court will instruct the jury, the fact finders, that they have to presume that the lost documents would have been harmful to the party that deleted or lost those documents. That's certainly not something that you want to have happen in your litigation. And in really egregious circumstances, a party might even be found in contempt of court if the court finds that the deletion was deliberate and in defiance of the court's expectations. And that can even come with significant civil and criminal penalties in certain cases. So it's not something to take lightly.
Which documents should be preserved?
So, as Jennifer already described, as soon as you become aware that there is an obligation to preserve documents, there's a threat of litigation or negotiations break down, or there's some indication that you're going to be adverse to somebody, you need to identify your documents and custodians of documents that are going to be most relevant to that dispute. So it's basically any document or data, electronic data, more frequently than documents these days, that could be relevant or potentially relevant to that dispute. So if the dispute involves a contract or a transaction, it would be any document, any email, any text message, any instant message, presentation, memorandum, anything that you could think of that relates to that contract or transaction for as much time as possible, going back as far in time as possible for all custodians. Once you identify those documents and custodians, you need to send out a notice to those people to preserve their documents. And that's the very most important step that you can take. If documents get lost, courts accept that mistakes happen and documents can be destroyed as long as it's an accident. But you have to give notice to your team, to your custodians, to your people who would have possession, custody, or control of these documents to preserve them and not destroy them. So you have to get that notice out as quickly as possible, and they have to specify the documents and data that have to be preserved. So you would tell people, do not destroy or delete your text messages, do not delete your emails, do not go into your Word documents, do not go into your files, just make sure you preserve everything. That's what needs to be preserved, Mika. It's really broad ranging, and that's another source of dispute in litigation that Jennifer and I see all the time is what documents were you obligated to preserve? Jennifer already talked about when documents had to be preserved, but there's also what documents. Really, it's best to err on the side of safety and be as encompassing as possible. And that's why we usually tell clients, if there's any relationship between the document and the potential dispute, preserve the document, because you're better off preserving it than deleting it and having to explain why you deleted it.
In light of all of this, what advice do you have for Japanese companies regarding document preservation?
Sure. Well, first and foremost, advanced preparation is so important. You don't want to be, for the first time, thinking about where your data are located, who are the relevant people to talk to when a dispute has arisen. You want to have that planned and your preparations laid out well in advance of the dispute. So as Mark mentioned, you will need to send a litigation hold notice to relevant employees. You should have a standard litigation hold notice already drafted and ready when the time comes. You should have your data preservation protocols established. Who are you going to contact in the IT department? Who are you going to put in charge of the document preservation efforts? What electronic discovery vendors might you need to use? These are issues that should be thought about well in advance of the dispute. And then think about where your data are located at the company. Do custodians have their own drives, individual drives? Do they have laptops? Do they have desktop computers? Does any employee bring a computer home or work from a home computer? You should think about and map out the location of your data so that you know where you're looking when it comes time to preserve data. Perhaps most importantly, and Mark alluded to this earlier, you need to completely understand your company's auto deletion policies and how to deactivate auto deletion quickly when the litigation is on the horizon. You should understand backup tapes as well. How are they maintained? What data are found on the backup tapes? How do you take steps to preserve them if you need to? And then think about other issues like departing employees. The last thing you want is for an important custodian in a dispute to leave the company without the IT department knowing that that data needs to be preserved. So think about policies and protocols around departing employees too, and make sure that your IT professionals know that they need to check and see if that person's data must be preserved for any reason. And finally, as I mentioned earlier, as part of your advanced preparation, you should ensure that your employees, not just your legal team, but also your employees understand the possibility that there may come a time when they need to preserve documents so that they are aware of and looking out for situations that trigger that duty to preserve, and so that they don't accidentally delete data because they're unaware that this obligation is out there.
Yeah, to me, I think those are great points, Jennifer. And I usually look at it like a fire drill or other emergency preparedness. You should have a plan, and if the plan's in writing, that's the best. And you should run drills to execute your plan to make sure it works. If you have a situation where you need to preserve documents, where do you go? How do you shut down the automatic deletion? And you have to look even outside your company, because it's documents that you have possession of, but also custody or control of. So that would include agents, brokers, third parties that would have documents, and you have to give them notice to preserve your documents as well. So one of the most important things you can do, in addition to having that good plan and preparedness together, is consult with a lawyer, somebody who's got experience in dealing with U.S. litigation, to help you figure out exactly what documents you need to preserve. Make sure you've done all the preservation steps that Jennifer just outlined to make sure you're protected and that you don't get in a situation where you're accused of destroying documents or data, and now their other side is claiming that you need to have one of those terrible results that Jennifer outlined earlier. So really, it's just about consulting with the right people, having a plan, and then executing that plan and making sure you're communicating with your employees so that, and management, to make sure that everybody's doing what they're supposed to be doing.
Thank you for sharing your insights today. 本日はご視聴いただきまして誠にありがとうございました。今後も引き続き US Litigation Now 3のビデオシリーズをご覧いただければ幸いです。ありがとうございました。